Hi, my name is Judge King. All right, realistically, we're going to talk about today judicial independence. I'm going to start out with the Federalist Papers, number 78. We'll talk about Alexander Hamilton and the things that he went through with the Federalists versus the Anti-Federalists. And then we're going to talk about some pressure points that come out in the judicial system. I may even go into a little bit of Madison and his 51, which is 3 branches of government. And then I'm going to hand it off to my good friend Darren. And we're going to talk about something that actually is in place and how you can replicate it in your district or your state or your circuit, et cetera. So why does this matter? Now, we all saw yesterday the panel that we had in the morning, the plenary, which was really good. But courts, we have to comply with the rule of law. And we're the last bastion to protect the Constitution. Okay, period. And so having said that, there's some things that we need to do to make sure that we survive as the third branch of government, an independent branch that was outlined by our founders in the Constitution. As Hamilton said, this is the least dangerous branch of government, okay? If you look at the legislature has what? Power of the purse. They get to fund things. Okay, that's cute. The executive, they have power. They have police forces going forward. We as judiciary, what do we have? We don't have a police force. We can't send people out to go arrest anybody. We can't do any of that. We have our integrity in the things that we do going forward. Now, one of the big things that was an argument that we're going to talk about here was we have to have structure of that independence. We have to have tenure of the judges, make sure that they're appointed for life. The selection and retention was one of those interesting things of how that was going to take place. And we're going to talk about the funding, which is one of those dimensions. But then there's the decisional aspect. When you have a judge, you want to have the judge be able to not worry about, I'll speak up. Okay. We don't have to worry about the pressure from people deciding what our cases look like. And we can tie this into some of the current things that are happening today. But yeah, I make a decision. And the first thing that I'm going to expect to see is something on social media saying that I'm crazy and I don't know what I'm doing and I should be removed. Okay? But that happens. But I don't do that because I can rely on my independence to be able to make those decisions going forward. I also have to abide by ethics and know when I need to recuse myself and when I need to leave and not do that. So let's go back into the 1700s when parchment was that day's AI and social media. Ooh, a little background. Okay. There was a debate. You had Alexander Hamilton, you had Robert Yates. Now, everybody remembers Alexander Hamilton as being the Treasury Secretary that died in a duel because he's a requited lover, et cetera, et cetera, et cetera. But he was an officer in the Continental Army. He was Treasury Secretary. And he fought really hard to make sure that we had this Federalist viewpoint of lifetime tenure, okay, that was important for the Constitution to be able to survive, that judges were going to be able to have permanent tenure going forward, and we're not going to be held to the whim of the mob. he was a Federalist. Then there was the Anti-Federalist. That was Brutus. Well, Brutus really wasn't Brutus. Everybody thinks that it was Robert Yates. And they were arguing, well, the people must be able to decide, not, the masses, not the wealthy people that are landowners that are congregated here, but we want everybody to be able to decide what's going forward in judicial independence and the integrity of going forward. The people, as he said down at the bottom, the people must choose. There was a big thought that when you give lifetime tenure that you're going to have people, because remember that we had just not just come through, but we have a king. We don't want aristocracies or fiefdoms being built in the judiciary. We want people to be able to be accountable and have to be responsible to everybody, not just one particular person. So this leads us to what they argued by and large is, what are the roles? One of the roles is we need to interpret the law, okay? It's a check on the other political branches. And most importantly, we need to be able to protect minority rights. Now, that creates some vulnerabilities. Selections get politicized. Now, in this room, how many people come from a state where judges are elected? Okay. How many are appointed solely by, say, the executive branch or the governor or something like that, or a commission? How many have a hybrid system? Okay. Next vulnerability is budget, money. We talked about the legislature being able to control what's going on. I have a friend back east who's a court administrator, past president. He's told me that the legislature is a little pissed off at the judicial branch and they're holding back money. So we'll talk about that a little bit more later, but that's one of those things that are always there. And then we always get these proposals about how we're going to change the court system. Court packing, we're going to add more justices, et cetera. In Arizona, I know that our Supreme Court Justice, Justice Bales, when he was justice, indicated to the legislature, I don't need another judge in the Supreme Court. We're just fine. But yet the governor put 3 more on top of on the bench, despite that. Information warfare. This is really important, okay? Especially today with AI, social media, chat bots going forward. And as I said before, parchment was the social media and the AI of the 1700s. Now, we all carry it around with us with our phones. So going back to the day, this was very important because they wanted to secure the rights of the individuals and not just Hamilton arguing on one side, but you had, the permanent tenure, the recipe for instability. They thought that state courts are no longer going to exist because they're going to be swallowed up by federal courts, and that this was not a good thing, especially since you had the 13 colonies that were trying to exert some sort of influence, but not be swallowed up in this new concept of the United States of America. As you can tell, Henry advocated against that. He was an anti-federalist. Hamilton said it's a necessary shield for liberty. Necessary shield. And these were contentious debates. So let's talk about what we're really looking at here, okay, today. Now, does anybody have any questions before I move on? Good. I'll come back to this. Good. Okay. All right. Public trust is very important, and it all comes back to public trust. Now, NCSC, there are 25 polls. So we're staying steady as state courts. Trend lines do matter, however. Thank you. You remind me of law school. Can you come have a seat? No problem. Okay. State courts, we still seem to be staying relatively there. However, the Supreme Court is losing their luster. Federal courts losing their luster. Governors, somewhat, and state legislatures are staying the way they are. So in this judicial independence, in the polling, we look like we're not doing bad, but we have some pressure points that we need to take care of and then we need to look after, okay? One of the big challenges is money and partisanship, okay? Money flows like no tomorrow as it relates to judicial elections. And that's one of the reasons why I asked how many people have a state where judges are elected. There were some very high visibility judicial elections coming up. Oh, I don't like this one. Okay, you come back. Did I go back? One too many. Okay. Did anybody watch the Wisconsin Supreme Court election? How much money was spent on that election? Close to $1 million, $100 million. Okay, for a judge's race. All right. So this year coming up in 2026, we have Michigan. You should watch. North Carolina. We should watch. Pennsylvania. No, you're done. We're done. Okay. There's a couple other ones that are there. Watch how much money is going to be flowing into judicial races that are normally not there. So this can be seen by outside groups as an erosion of independence. Now, ballot measures are also going to be out there to change court structures, to add more judicial districts or judges, et cetera, to reshape a variety of different things. So look to see how Sandra Day O'Connor, Justice O'Connor's plan on judicial performance evaluations and how they're being applied to maintain judicial independence, okay? Another pressure point is we talked about these dollars. Shielding us from the financial pressure, making sure that the budget's there. Some people may have flat budgets. They didn't get any increases. And that means that you can't hire the people necessary to be able to process the people through the court system, and you're denying them access to justice, which creates a problem for independence. The solution, let's make sure that we have structures that don't get into retaliatory funding like they do in back east when the legislature says we're not going to give you any more money because we don't like what you did when ruling against us. And try to make sure that the institution is not being viewed as, well, we're going to give you this gift because we like you, but we're going to make sure that we know it's necessary for you to implement the rule of law. Most importantly, social fake news versus facts. It's there all the time. This is one of the most hardest things that we're going to have protecting the independence in the judiciary. is the integrity of the program of the judiciary in an AI era. Because you don't know what's fake, you don't know what's real. I have a friend, his name is Mark Lanterman. He runs a forensic lab. He's a former Secret Service agent. And we would always talk about how do you view a photo that's been photoshopped and you can look at the metadata going forward. Well, that's fine. And I kept telling Mark, I said, Mark, here's the problem. If I create a video, I create a photo, the metadata is the metadata. It's not been altered. It is its own original metadata. And so how are you going to be able to tell that it's different? It's a hallucination. If it's a deep fake, what are you going to be able to tell? You don't know if it's real or not real, because you can't use your standard techniques of, oh, I'm going to look and see if the zeros and the ones have been altered. False narratives about the court spread quickly, okay? Real quickly. Really, really quickly, okay? So, as a court, okay, we need to be proactive in education. Now, there's the National Association of Judicial Educators, correct? The Conference of Chief Information Officers, I believe that's correct, okay? If you have them in your court, use them. They will help you get out the information about what the judiciary does. They will help you developing a rapid response plan to deal with myths that are out there, okay? Most importantly, we need to protect the third branch, okay? It starts by who's chosen, okay? Make sure you understand the process. Is it a Judicial Selection Commission that helps protect that independence? So it can't be said that they are beholden to one political party or another political party. Is it the funding opportunities so that the bench can't be viewed as a political weapon? Well, we're going to cut you because we didn't like how you ruled on our redistricting plan or our funding stream for a project that we have a pet project for, okay? And make sure that information that's out there on a proactive basis about what the courts do. So therefore, we can protect that. Now, it's not self-sustaining, okay? It's very fragile, very fragile. And just how I started, I said, we're gonna do a little self-care, we're gonna get up and breathe. Judiciary needs to do self-care and make sure that it protects itself. Maintenance and public advocacy is very important. And with that, we're going to talk about a real-life case study, a real-life incident of what's going on, and I'm going to turn it over to Darren.
Thank you, Judge. So yeah, again, my name is Darren Breslin. I work with the Administrative Office of Pennsylvania Courts in Philadelphia and Harrisburg, Pennsylvania. And about 20 years ago, just about 20 years ago now, our state Supreme Court was looking at threats to judicial independence. And our chief then, Ralph Cappy, was really concerned that the defense, if you will, of judicial independence wasn't adequate. Typically, in all of your states, probably every state, every jurisdiction in the country, it's bar associations and civic leaders who surround the judiciary and provide their defense, because judges really can't talk about their rulings. They're limited by their code of ethics. Their opinions generally speak for themselves. So if somebody complains about a judge, the judge just kind of has to take it and hope that somebody else will correct the record. And Ralph Cappy and our Supreme Court at that time were really forward thinking. They thought, no, we need to provide some base level of protection for the courts. And he thought the best place to do that was right out of the state Supreme Court. Carefully, we can't get involved in politics. Strategically, you don't want to counter every false fact or misrepresentation. That just breathes more life into things. But he wanted a dedicated group to brainstorm and use the appropriate means to provide some layer of protection for our courts. At that time, way back in 2005, 2006, we were dealing with what many of you have dealt with, this call just to throw all the bums out. Electors and political parties in Pennsylvania were really disappointed with some rulings that came down. There was a pay raise decision, and people were blaming all the local judges for that decision. They had nothing to do with it. And this court put together this group of academics, of judges, business people, political leaders, to provide one, best practices, and two, some vocal response. Now, this is 25 years ago. Things were different then. But I'll tell you the kinds of things that the court put together at the time and how they worked, and then how we've transcended that and gone to the future. Back then, people still read newspapers, so letters to the editor would be one response that they did. So we would get a team of well-regarded academics from all across the Commonwealth of Pennsylvania to volunteer at appropriate times to pen a letter in defense of the judiciary, whether it was defending a local magistrate judge for a bail decision, and the story came down that this judge is just soft on crime. And the letter to the editor in that case might be something along the lines of, here's our state rules on how you set bail, just so you know. And these get evaluated and weighed, and these are changeable. If someone disagrees, you could appeal a decision from that level. You can ask for reconsideration, just setting the record straight. And I'll get back to that in a minute. If it was the case, it was a matter of someone upset with a Supreme Court decision or an appellate court decision, and saying it's all party politics. Well, one of our academics might come up and give some of the history of that issue and say, well, here's actually what the points are, and this court felt this way. Not trying to speak for the court, but just explain publicly in writing. Like I said, people read newspapers at that time, so that was a viable means of communicating. They would also put out workshops, publicly available workshops. For the lawyers, they would get CLE credits if they showed up. We worked with the CLE board to make sure they would get it. But we would go to universities, big universities, University of Pennsylvania, Pittsburgh, and then smaller ones too. We would go to community colleges, wherever we could get a seat. And we would put on forums to discuss issues of the day. We would invite the press to come in and give them plenty of access. And we would bring in our Chief Justice to talk, or Associate Justices on our Supreme Court, our local president judge if it was a county. We would bring in political leaders if they wanted to be involved. There were a few sessions where we had the Speaker of our Pennsylvania House of Representatives was part of a conversation. The President of the Senate was part of a conversation that we had. And we would we did a judges and journalists workshop, which was really well attended. C-SPAN covered that one too. We brought in a panel of judges from appellate courts and trial courts and journalists from major markets. We sat them at a dais, and it was an open discussion. And our goal was, what do journalists really need to know from courts to do their job well? What information do they need? And judges, what do you need to be cognizant of that your journalists' readership needs to follow? So it was a learning experience. It was really well received because our judges picked up tips on how they could talk from the bench, things they could put in their opinions that wouldn't change their opinion, but they might frame out an issue and differently so that readers could follow it more logically. It prevents misconceptions and misreporting, which is the biggest issue we've got. And on the flip side, journalists understood more of what judges need to do in individual cases, preventing misconceptions. A big problem then was, and a bigger problem now, is a lot of markets don't have the journalists to cover the courts and crime reporters that they used to have. So it's even more important now that to the extent they can, when judges are talking from the bench or issuing written opinions, providing enough information so that people beyond that case can understand what they're doing. preventing, as Judge King was talking about, preventing misconceptions is huge for judicial independence. If you can convince people that judges are not in this for the political win because they were elected as a Democrat, so they're going to hold that banner, but they're actually just trying to apply the law, you've done a great service. We did, like I said, judges and journalist workshops. We did a great workshop with our Chief Justice and our head of the Senate sitting down for a one-on-one conversation, a discussion moderated by a former governor. And this was on court funding. And it was fantastic because our courts, through our Chief Justice, got to talk to one part of the legislature, the state Senate. What do we mean by adequate funding? What exactly are you funding? Now, of course, the senator already knows this. He gets the budget briefing every year. He knows what the courts want. But this wasn't for him. This was for the people in the audience. This was for the people at home watching on Pennsylvania cable news. Not a great market for Medium, but, it's something. But it gets it out there. All you can do is try. All you can do is put the information out there and hope it reaches the right people. And again, we'll get back to that in just a minute. But it's wonderful when you can get somebody on the record agreeing with you that, yes, the courts do need to be adequately funded. And, in the next few years after that, the court's budget was actually noticeably better. They got a little bit more money, never as much as we need, ever. We all deal with that, but a little bit more, and that helped. And that, again, was very well received. These sort of open discussions, these panel discussions, that's how this group sort of evolved. It went through, this Judicial Independence Commission went through. They would put on a program every year or two. It became a little bit stale because the times were changing. And people weren't watching news channels for information. They weren't reading papers as much anymore. The websites were there, but not really that much. And then, of course, COVID happened and everything shut down, including this commission. After COVID, I guess in 2023, 2024, our Chief Justice and our court decided there are new threats to judicial independence, and it's coming from AI. It's coming from attacking judges more personally for decisions, from other political branches, from individuals, from political parties, from all over the place. And there was a real concern that judicial independence is under a new threat, and it was time to get new ideas on how to defend judicial independence. And what does that mean? Well, first of all, we brought in people who were younger and younger intellectually, not even necessarily chronologically, understood how to communicate better to our markets. For the first time, they brought in our public information officer, Stacy Witalik, who was fantastic, and her team to help this commission, reconstituted, understand how to reach people. How do you reach today's market? And it's not through a cable news broadcast, or it's not through a letter to the editor. It's not through writing anything on paper at all. Parchment, that's yesterday's AI. How do you do it? So now we've got websites. We're on Instagram. We're on Twitter. They're doing more with graphics. They're doing more with outreach to where people are. The group is being more active too, locally and statewide. And what do I mean by that? Before, the commission would put on programs to entice people to come. And we get a couple hundred in a ballroom like this. It might be recorded, might be a couple journalists in the audience. That's fine. Well, no, now they're going out more to academia. They're going out to the schools. We're inviting different interest groups, everybody from the Elks and the Rotaries and your small interest groups to universities, to hospitals, to anybody that wants to have a lecture on the courts and what they do. We'll send people out. We've got our trial judges around the state signed up to be volunteers. They'll go out. If it's something locally and they can fit it in their schedule with enough notice, they'll go out and they'll talk. And our group put together talking points. What can you talk about to your local constituents? What's important? This has worked out very well. We get calls, and we're sending judges everywhere from Scranton, Pennsylvania, way up in coal country in northeast Pennsylvania, down to Pittsburgh in the southwest, and everything in between. A lot of things that people are talking about today are civics education. I didn't build my conversation around the slides, but I put them up there for your information. Educating people on how judges make decisions, programmings, highlighting the court's impact, and partnerships with the bar, with academia principally, and just with different interest groups. Also, while I'm talking, if anybody has questions, feel free to raise your hand. I'm happy to take questions on the fly, or else we put time in at the end. But I can talk to you more specifically about how this group operates. And one of the big things I'm not going to get into a lot today is funding and how you deal with funding for these initiatives, but I can talk to you about that as well. Civics. Civics is this, everybody talks about civics. We need more civics. There are more groups advocating for teaching civics than you can shake a stick at. And we don't need to be one of those groups. That sounds controversial. What do you mean we don't need to be one of those groups? We don't. The courts are great at doing it, but there are so many groups that are putting that out there. Our commission has decided that this group's best efforts are spent in helping others who are developing civics curriculums to include the courts. We're the experts. You know how courts operate. Your judges know how courts operate. General civics, with their schoolhouse rocks mentality of following a bill through and legislative process, that's great. But what does that have to do with decisional independence? What does that have to do with institutional independence? Those lessons are often left out of rote civics education curricula. So our judges and our educators go out there and make sure all of these things come into civics curricula, and we offer to come out and help teach it if you want. Again, to schools, to colleges, to universities, to bar conversations with local groups, whoever. Understanding what courts do, how cases flow, how decisions are made, what are the various decision points, understanding the rules. Why do courts decide the way they do? Well, there's actually rules, substantive and procedural rules they've got to follow. This helps dispel myths. This helps give people confidence that the judiciary is doing well. You're always going to have groups that are convinced there's nothing you could tell them that this judge is a Democrat. He's always going to go that way, and this judge is a Republican. That's always going to be there. But people are generally reasonable, and if you give them information, they can understand what you're doing. And we've had a lot of success. People respect our groups coming out and speaking about the different things with civics education and how courts operate. It does wonderfully. Constitution Day, Law Day, these are great opportunities to get out in your community, to talk to different schools, to put out social media, advertisements, functions, learning opportunities, webinars. Use the technology that's out there because you can reach a lot of people. And we're reaching enormous numbers of Pennsylvanians and beyond with our messages, which is really gratifying. You can come up with neat little posters, and feel free to copy any of this. I've got permission to share this with all of you, or if you want copies, we can send it out. Stuff like this that's colorful, that's enticing, that's appealing, this resonates, and we've sent this out statewide to different schools and different interest groups. Like I said earlier, the Elks, the Rotarians, they're all fantastic. How courts operate, what resources they need, how our Constitution is set up, why we vote for judges the way we vote for them in Pennsylvania, what are retention elections and why that should matter to you. We try and educate as much as possible using the different media that's available today. And communicating with your local academic resources is fantastic. We have a great partnership with Ken Gormley out of Duquesne University in Pittsburgh. And Ken is just a rock star for us. He was able to last year go up and have a one-on-one conversation with former Justice Breyer and talk about judicial independence. And he sent a message directly back to our trial court bench at a video played at our conference last summer. This is property of Duquesne University, but Ken has told me to offer it to all of you free of charge. If you need a link, let me know. He's happy to send it to you. Use it. If you find any parts of it that are helpful in your jurisdiction, he's happy to share it. It was a really interesting conversation. It wasn't political. It was personal. It was talking about really the importance of an independent judiciary for all the reasons Judge King just mentioned. And I encourage you, watch this when you get a chance. I think you won't be disappointed. I talked a little bit about funding. The court is very cognizant of funding. We can't be spending public monies to advocate political positions. So that's why the court is always going for partnerships. Partnerships with the Bar Association is always your first choice, but bar associations are struggling like everybody else. Law firms, to the extent they're natural partners for this. Sometimes law firms are happy to host local symposia, local conferences. We can get some money from them. It doesn't take a lot to do this. The resources you have are in your judges, are in your administrators, are in your court workers. Those are the tools you need. And it is so cheap to get a message out there today. We can see by all the awful messages that are getting out there, anybody can do it. So we can do it too. Use social media, use Instagram, use X, use the methods and means that people are using today to get their information. Nobody's reading newspapers, but they can tell you what the top stories are from Facebook. So use them. That's all I've got for this part, but I'm happy to answer questions if you've got any. Judge King, I'll throw it back to you. Oh, is there a question over here? Now you got to wait.
Hi. Did Pennsylvania's Supreme Court approve this?
Yeah, they did. They approved. Did they approve when you say this? Me being here? No, I'm going rogue.
No.
Sorry.
Yeah, the organization that you were just talking about.
It's a creation of the Pennsylvania Supreme Court. What's interesting is you can't avoid the fact that it's a government entity. It belongs to the Pennsylvania Supreme Court. But they never, not once, has any Supreme Court justice told this group what to say or how to say it. They keep a very hands-off position, which is good.
Short video.
Judges around the country have been under attack for unpopular rulings, much more so than in the past. The role of courts is not to please politicians or special interest groups, or to make decisions based on public opinion polls. The role of courts is to provide the essential balance in our three branches of government that our founders envisioned, to render justice to the least powerful as well as the most powerful. Judges must withstand the pressure of political and public opinion and make decisions that they believe are legally correct and in accordance with the law and the Constitution. Sometimes politicians or political activists criticize judges because judges fail to rule their way or according to popular opinion on controversial cases. But it's not a judge's job to be popular. Judges understand that every decision they make is likely to make one side or the other unhappy, and sometimes both sides. That's part of the job. In a democracy, everyone has the right to criticize or differ with a judge's opinion, but attempts to undermine a judge or a court itself strips the court's powers and undermines our democracy.
You do these events, but make sure that you can track and figure out what's going on. And so, how many media hits do you have? Who your partner organizations are, and go back and have feedback from them. Get conversations and have and see what are our measures, the trust measures that NCSC does. Make sure that you have your own polling, internal polling, so that you can figure out what your level of trust on your courts are. Okay, going forward. Do we have some problems that we need to address? Do we have some things that we need to figure out how we can improve upon? One of the things that Darren talked about earlier was, you may have a magistrate judge that has a bail decision that everybody's a little pissed off about. Why are you letting this person out? Well, how do we deal with that? Is it a reform issue or is it an education issue? And who do we need to talk to make sure we can get that kind of information out? The surveys, the judicial performance evaluations, that is an excellent tool to be able to use to protect your judiciary, to make sure that people understand that we're not just putting people on the bench, period, but we put them on the bench and we evaluate their performance. Now, it's interesting because this morning, I had breakfast. Well, the breakfast was horrible, okay? You don't get French toast cold. The butter's supposed to melt, okay? So when you send it back and it comes back and the butter still doesn't melt, it's one of those things. And so when the person says, well, we're going to take it off the tab, I said, no, I have to pay for it. I'm a judge. I have canons. I have ethics that I have to do this. I'm not getting a free meal. And general public doesn't understand that. But you explain, thank you very much. I will make sure that I leave a tip or going for it, and you can figure out what you want to do for it, but I have to pay for the meal that I ordered. I'm going forward. And those are little things that the public does not understand about the judicial branch. And it's not just for a judge, but clerks, administrators have those same canons. Okay, so this would have been if we had round tables going forward, and we would ask you to separate into groups, and let's talk about how do we develop a playbook for your state or your jurisdiction, et cetera, going forward. But since we don't have that, we're going to talk about this as a mass group. The entire table is everybody here, okay? So if we were to create a commission, what would be one mandate that we would have going forward?
Don't be shy.
Come on. How about information? Access. So access to what? Justice. Access to justice. Maybe why we think the rule of law is important. Okay. As a foundation for our commission. Then what would we do next? Okay. Maybe pull out the Chief Justice. Could you invite these people to a meeting? Lunch is always good. Always good. Even if it's Subway, or Jimmy John's, I got to be fair, or who's some Firehouse Subs, somebody like that. But make sure, you get them all in a room together and you talk about what can we do so that you understand the information. Now, one of the things that I think that's interesting that we don't really talk about is how do you involve the media? And in a little side note we had, it's people's court systems, we don't talk about them that much now, are getting hacked for ransomware, et cetera. Okay. You should have a table talk exercise about if we get hacked, what happens, who makes these decisions, et cetera. And when you do the table talk exercise, invite the reporter that's the most pain in the butt to come sit at the table talk exercise. Because when it happens and everybody goes on shutdown, all right, and that reporter says, what's going on? Well, you sat at the table talk exercise. You know what we're doing. You know what our processes are going forward. So that way you include people that may be your adversaries, or as you perceive, that give you the most grief, but they're going to be your warriors and people that will advocate, well, they're doing their processes and they're going to do the stuff that they need to do. Create a speakers bureau. Who are we going to send out to talk about bail bonds and what we do and how do we implement them going forward, okay? The next thing is establish an annual report and metrics. You got to measure everything. Numbers. How many people did you talk to? How many meetings did you have? What different communities did you serve going forward? And that AI rapid response. I truly believe in this. Because basically, I'm a bad judge, okay? I'm horrible, I make bad decisions, et cetera. That's social media. So how do we counter that? Well, let's talk about the things that he's done in judicial education. Let's talk about the things that he's done to make sure that the community is safe. And most importantly, understand performance evaluations. Now, I know in Arizona we have retentions, and those are coming up, and we have a performance commission that evaluates people going forward to determine whether they should be up for retention, not up for retention going forward. There are different members that serve on those commissions: public members, judiciary, state bar, et cetera. Make sure that you get people involved in that, and that's their way of being able to, and how you couch it, protect the judiciary, protect the independence of the judiciary, to make sure that we get fair, accurate, unbiased judges going forward. All right. Here's the playbook. Now, Darren's included a lot of stuff in the, there's a one-page, not one page, but a file that has 1 pages that you can fill in the blanks in the materials for the seminar, and some forms. And it's definitely a skeleton. It's not something that's filled in detail so that you can use it and adapt it to your own particular jurisdiction. Okay. The 1-pager, 5-minute remarks. How judges are selected. The slide that Darren went through that had this is what courts do, et cetera. Okay. As long as we attribute, can we borrow it?
Absolutely.
Definitely. Okay.
Judge,
Yes.
that brochure, as well as the link to the video, is at the bottom of the session information in the app.
Okay. All right. This would have been build your 90-day plan. Okay. And put it up. Now, what time is it? One was there.
It's 10.
Oh, okay. All right. So this is most important, I think. Judiciary's last marks. You got to remember on the left, it's not self-sustaining. It's vulnerable to political pressure, vulnerable to disinformation, okay? But it requires structural safeguards, ethical vigilance, okay, and public education. And we have to safeguard, as Hamilton said, against ill humors, i.e., bad thoughts about what a judiciary is and what it does, i.e., we're not little fiefdoms, okay? We are there to protect the rule of law, protect the Constitution, and contrary to what the Anti-Federalists said, that we are there for everybody, not just the rich, but everybody. I'm disappointed we didn't get the video. I don't know. I have no idea how to work this computer. I'm not that bright. Yes, I think, well, that's one.
So there's some things you all can do back home right now that doesn't require any real money, doesn't require any real time. It's great to ask your judges in your jurisdiction, hey, get out there and talk to groups and defend the judiciary. And they'll be all for it. That'd be great. But you need to give them ammunition. So one thing you can do back home right away, and I'd encourage you to, is gather a couple of really smart people in your area from both sides of the political spectrum, have them sit down over lunch, because people love to eat, and talk about the issues and figure out what is a measured, appropriate response to a criticism that may not necessarily be accurate or fair. From that, develop some bullet points, develop some talking points on both sides. So if somebody is, if a common complaint in the community is this judge or this appellate court only ruled this way because, pick a side, pick a position. I don't care what it is. It doesn't matter. And usually it's not accurate. It's not accurate at all. It's a political point that they're trying to make, or they think everything revolves around politics, because sometimes it really doesn't. Give them the bullet points to be able to respond appropriately and quickly. That's an invaluable tool, giving those sorts of things. Another thing that, I know you're all flush with money and you got plenty. Is anybody from Arkansas here? I'd encourage, if you can, Marty Sullivan, the court administrator down in Arkansas, his court, they did an amazing job in Little Rock in their judicial center on civics and on court-centered civics, I'll call it. Their whole lobby of their justice building is kiosks, videos, interactive displays, historical markers, the whole thing. Walking around, you get what does a judge do? Be a juror. Talking about how bills get passed and about judicial review, what that means. I was inspired leaving that courthouse last week. I was down there for another conference. And if you get a chance to get over to Little Rock just to see that, I'd encourage you to. It's really, really snappy. And all things considered, with the way how little things cost now to build, it wasn't really that expensive. They make it available to schools around the state to come in and do free lectures there, or free seminars or workshops. And they're getting a lot of people to come through. And they learn by osmosis. You come in, you can't help but see the impartiality just by walking through. They've got judges from different political parties there working side by side, explaining things. And they're well known in their community. That's a D and that's an R. But that's not what it's about at this point. It's about impartially applying the law. And that's the strongest message that we can give for judicial independence. That's what it means. It has nothing to do with what letter was after your name in the last election. I can dance, but nobody wants to see that, so. I know you do.
Does anyone have any questions while she's still trying to pull up the video? All right.
I don't know if this is really a question or probably more of a statement, but you talked about on one of the slides public confidence being eroded in the judicial system. And you showed a poll that showed that state courts tended to have a little bit more confidence than the Supreme Court, which I would suggest that that's probably going to eventually bleed down to the state courts as well. Let me preface this by saying I'm not a lawyer. I just like to keep things simple. And I think the thing that erodes confidence more than anything is the system is too slow. And the example I'll use is birthright citizenship. The current administration tried to erode that with an executive order or a decree. Not in this past January, but January of last year. Why is it taking so long for the Supreme Court to take up that issue? That tends to erode people's confidence in the whole system.
It is a loaded question. And one of the things I will say is, as a judge, whether I'm a tribal court judge, a municipal court judge, a state court judge, I'm ascribed to the characteristics of judges from the Supreme Court. So every time they do something that I think is boneheaded or stupid, okay, oh, you're a judge, so you must be one of them. This is what's happening, all right? And that comes back to that information thing. I don't have a shadow docket. I do my orders. They come out, period. And everybody knows what my decisions are. But yet, That's a court that hides behind, this is my opinion, hides behind, we can't talk about things. Well, we need to explain to the public why and how we make decisions. You know, what do they say? Sunshine in the light of day is the best disinfectant there is to understand everything. So if you understand why they're making decisions and people sign their names to them and you can read them, that's the best thing to do to go towards their trust.
We did one of the smartest things possible is we hired a 20-something. We have a person who works with our PIO does graphics and this is what she does. That's her job, not just for the Independence Commission, but for the whole Pennsylvania administrative office. It's amazing what you can do, and really at this point with AI and with the software that's out there, you can come up with some pretty sharp stuff and develop it relatively inexpensively. It doesn't cost a lot of money. If you got the people who know what they're doing, they can do it really well. Yeah. Yeah, and if you have questions about what your either county, municipal, local level information officer or group might be able to do, my contact information is in the material. I'm happy to put you in touch with the people in my office who know what they're doing, not me, to do stuff like this. How did they go about it? What programs did they use? What contacts did they make? A local school of communication is great. You can get students working on things with you. Or you can just develop it in-house with some people who know what they're doing.
When you talk about local schools, you have graduate students that are always looking for projects. And so you utilize that. And it doesn't have to be a graduate student, it's just a student period that's looking for a project that they can do something with the court to create a video like that about judicial independence, about what we do as a court. So you can send that out and put that on the court's website.
Any other comments or questions? Don't be shy. There we go. Thank you, Stacy.
Good morning. More of a comment. When speaking about kind of developing these commissions and bringing these justice partners together, I also think it's really important to bring in folks that have lived experience in the court systems, whether that be, victims, whether that be family members, whether that be persons themselves that have, gone through criminal cases. We have a really robust peer program here in New Mexico. So I just think whenever possible to really center the voice of those that have gone through the system kind of on the other side. I think we get a little narrow-minded when we're working within the system. We haven't necessarily experienced it as a court user. So just a comment that I think we all need to kind of keep considering where we can plug in folks with that lived experience.
Well, to dovetail on that, sometimes when you have people that come through, you ask them, what could we have done better? You came through the system, you were a victim or, yeah, they're going to be a little pissed off because they may have been found guilty. And have to pay a fine, but what can we have done better for the customer service? So,
yeah. Do you all do that with your jurors now? Do you do juror exit polls and what experiences you have? Expand on that. Use that not just with your jurors, but the same concept with litigants. You're going to get some that think you're just Satan's sister, but but you're going to get some really helpful information, some good feedback. Hey, maybe we could do this a little better. It could be something as simple as the area where people were seated. Were they treated with respect and dignity, or did they feel like they were just cattle, just moved through the lines? It can make a lot of difference. And that, too, goes a long way to providing the independence of the judiciary and giving people the realization that it's actually an independent branch and it can be fair and impartial.
And it's there to protect you.
Good morning. We've recently started this year doing judges in the classroom, so an education piece in the elementary schools and in the high schools. More so, we started focusing on that because we are not seeing a really great turnout in potential jurors. So we really are focusing on those high school age children, kids, also throughout the different levels of school, but focusing on the high school kids that are turning of
voting age, of age where they can sit on juries and those types of things. So our judges are going out to the classrooms. They're educating the students on different levels of where they are in their own education pieces. High school students more so on what the experience is like as sitting on a jury, what the court processes might look like as a generalized piece, because you don't have that much time sitting with them in a classroom. But we have found that we're getting a lot of positive responses from the schools. They're posting positive responses on their social media accounts, on their different things. So I also do agree that education, starting in lower grades, is also really a positive thing for the judiciary, as just getting people familiar and understanding a little bit more about what it is that we do in our jobs, our day-to-day jobs, and how going to court works, and what those things are. So I did like the slide on the different places to go to talk about what it's like to be in a court setting, or the different things, educating the community more so on that. So I do appreciate that. And I'm very much interested in some of the stuff that you were talking about regarding education pieces. So I just wanted to make that kind of comment. So if anybody has got that opportunity, I would encourage that with the classrooms. We've had beautiful feedback. Thank you.
Another thing that occurred to me when the judge was talking about dissatisfaction and trust and confidence with the federal courts versus the state courts, it reminded me of one thing that we try carefully to avoid, and that is you have to know what to respond to and what not to respond to, when to make a stand and when not to. Recently, there's been some, we'll call it criticism, from the White House on different judges and attacking different judges for their rulings. However you feel about that, we try very hard not to respond to that from a state court perspective for two reasons. Number one, that's not our fight. That's for the ABA to fight. That's for somebody else. Number two, we don't want to mix our judges up in the same conversation with complaints about judges elsewhere. So while any lawyers in the group, any you're all court people, you want to defend your judges, you want to stand up and say no, that's not right, that's not what it's about at all. We stay quiet out of respect for others, and also because be careful what fights you pick. You don't want to all of a sudden say, well, not to use you for an example, but you're the closest judge. Judge King ruled this way because blah, whatever. And in Pennsylvania, we say, no, Judge K did not do that. Well, I don't want to be in the same conversation as somebody criticizing a judge in another state. I get no benefit out of that. Unless it's an issue that's really important to Pennsylvania, we're not going to touch that at all. No disrespect to our federal brothers on the bench up there, but that's brothers and sisters. I'm sorry, I'm inclusive. Brothers and sisters on the federal bench, we can't pick that fight because it's diminishing returns for us. We're going to stick with the arguments against Pennsylvania judges only, typically.
Anyone else?
I think we're good.
Not bad.
Okay. So on your app, there is the rating. If you will please rate the speakers and the session. And thank you very much for coming.